I'm a defense attorney. And here's the truth no one really wants to hear: about 95% of the people we represent are actually guilty. But that doesn't affect how hard we fight for them, not one bit. That's because people misunderstand what the justice system is really about. It doesn't exist to determine guilt or innocence. What it actually does is answer one question: has the state presented enough evidence to justify locking someone in a cage against their will? That's it. Whether a client committed the crime doesn't change that central issue. In fact, in over 90% of cases, even for aggressive lawyers, it all comes down to plea bargaining. The typical client? They're guilty of something, and there's usually enough evidence to prove it. But the charges brought against them are often inflated. Our job is to find a reasonable outcome based on the strength, or weakness, of the prosecution's case. Going to trial? That usually means negotiations have completely fallen apart. Either the prosecution is being unreasonable, or the defense has no other option. Now let's talk about overcharging, something I've seen brought up a lot in the comments. Yes, it happens constantly, especially in low-income communities. Prosecutors and cops often start with the harshest charges they can justify on paper. Here's what doesn't happen: a guy steals a pack of gum and suddenly he's charged with murder. That's nonsense. Legal bargaining isn't like haggling over a used car. There's no highball/lowball tactic where we meet in the middle. Defense attorneys have access to the evidence. We know what a fair charge looks like. Let me give a real-world version. A guy steals a pack of gum. The state charges him with robbery, battery, assault, and resisting arrest because they claim there was a minor scuffle. I go through the evidence and see that the theft is a slam dunk for the prosecution. The scuffle? Weak. The resisting arrest? Maybe. So, we agree to plead to theft, tell them to get lost on the rest, and maybe negotiate down the resisting charge. Now, if I think the robbery might stick, I might advise my client to eat the resisting charge to avoid a 10-year sentence. But if I'm confident robbery won't hold up, we dig in and only plead to theft. So yes, overcharging can apply pressure. People sometimes plead to slightly heavier charges than they deserve. But are good attorneys letting clients plead to ridiculous crimes they didn't commit just because the state throws out bogus murder charges? Absolutely not. I'll share one more thing, another defense attorney's take, which I fully agree with: the system is brutal. And honestly, if one or two guilty clients walk free, I can live with that. Because overall, the work we do pushes back against a system that disproportionately punishes the poor and vulnerable. There are two types of defense lawyers: those who live to save the innocent, and those who take pride in protecting the guilty. I fall more into the second group. Most of us, especially in smaller towns, know that the punishments and fines thrown at defendants are excessive and designed to keep marginalized people oppressed. Story 3: The harsh realities of justice and why defense lawyers do what they do. Let's talk about how punishing even small infractions can be. Simple marijuana possession? That can cost you around $600, 2 days in jail, and mandatory substance abuse classes. If you're caught operating a vehicle while intoxicated, even if you're just sitting in your car with the engine on to keep warm, you're looking at $2,000 or more, a suspended license, increased insurance rates, and at least 2 days behind bars. On top of that, most sentences come with 1 to 2 years of probation, and if you slip up even a little during that time, it can mean 90 to 180 days in jail. From reading countless defense lawyer blogs, I've realized the core mission isn't just about helping people get away with crimes, it's about defending their right to a fair trial. Even when someone is clearly guilty, prosecutors often overcharge, piling on extra counts for things they can't even prove. The state holds immense power, and for the average person, it's like standing in front of a tank with a stick. Defense lawyers are the ones standing between you and that tank, making sure your rights are respected, or at least bargaining so that you don't give up those rights without something in return. Whether you're innocent or not, the system comes at you hard. And a good defense attorney will protect everyone's rights equally, no matter how ugly the charges are. One article that really stuck with me is from Chasing Truth, Catching Hell, titled Dear Norm, How Do You Actually Defend These People? It dives deep into the mindset and the practical steps of defending someone accused of a horrible crime with no clear defense. Here's the essence of what it said. First, the lawyer has to mentally prepare for the likelihood of going to trial, especially when the prosecution is pushing for the harshest possible sentence. The lawyer might personally believe that the defendant is, in fact, guilty, and even that they deserve prison. But that doesn't erase the attorney's ethical responsibility to ensure the client's rights are upheld, unless the client is getting something fair in return for waiving them. People facing serious charges often feel powerless. When they see their own lawyer as just another cog in the machine trying to steamroll them, they resist everything, including helpful advice. So, the attorney reminds the client, "This is your case. You decide whether we go to trial. You choose whether to testify." But they also help the client set realistic expectations and goals. Behind the scenes, the lawyer documents every move they make. And why? Because if things go south and there's an appeal, a new attorney will dig through the entire case with a microscope. If there was any major error, that new lawyer can, and should, argue it in court. And if the defense lawyer didn't do their job right, the appellate attorney will make that very clear. I recommend reading the full article. It's powerful and eye-opening. The original poster who shared it may not be a lawyer, but they really did their homework. Also, you're not alone. A lot of people struggle with the word appellate. It refers to appeals courts, where lawyers challenge the outcomes of earlier trials. And yes, it's pronounced like appellate. Story 4. The Client Who Got Lucky. I remember one guy who had a lawyer he trusted. He confessed to stealing an Audi, Grand Theft Auto, and told his attorney everything. But he wasn't alone. He'd done it with 4 other people. His lawyer didn't rush into a plea deal. Instead, he pushed for continuances, delays in court, to watch how the prosecution built their cases against the other defendants. By waiting strategically, his lawyer was able to navigate the case in a way that worked out shockingly well. In the end, the client got off practically scot-free. Just a year and a little probation. Timing and patience made all the difference. Story 4 continued the power of lawyering up. About 6 months after it all went down, one of the guys pled guilty and ended up in a safe house program. Another got probation. The last 2 of us? We walked away clean, no charges, no record. I barely had to speak in court, aside from requesting continuances when my lawyer couldn't show up. Eventually, the whole case just faded away. And here's the thing, I was the only one who immediately got a lawyer. The guy who landed in the safe house got tricked, the cops told him. "We have you on video." Even though no such footage existed. He didn't have a lawyer present and panicked. If the rest of us had all lawyered up from the start, chances are none of us would have served any time. We weren't hardened criminals. We were dumb college kids who took a car for a joyride, the keys were inside. We ditched it somewhere else and thought we got away with it. But word got around. We ran our mouths, and someone connected to the situation, possibly mad about a stolen girlfriend, went to the cops and spilled everything. That's what brought the heat on us, not evidence, not police work. Just gossip and betrayal. This happened about 15 years ago, back when I was in college. Lesson learned? Shut up and lawyer up. Story 5, Defending the Guilty, Upholding the Law. I've left comments all over this thread, but here's a more direct answer to the original question. What's it like to defend someone who admits they're guilty? It's the same as handling any other case. Just because someone confesses doesn't mean my job changes, except it often makes my job easier. It also means that my ever-growing list of acquaintances now includes another alleged assaulter, drug dealer, thief, or domestic abuser. If you judged me by the company I keep, professionally, I'd look like I hang out with the worst of society. But how I feel isn't important. What matters is what I do. In many ways, it's easier when a client admits guilt up front than when they deny it and swear innocence in 20 different ways. Every person has the right to plead not guilty, and it's my responsibility to make sure their rights are protected, no matter what. I always start from the top. Was the investigation constitutionally sound? Were there problems with how the search was conducted? Was the traffic stop legitimate? Was the lineup done properly? Was the confession coerced? And thank God for the clients who know how to keep quiet, because silence can be the only thing standing between them and a long sentence. A professor I had once despised the phrase, "on a technicality," and I agree with him. These technicalities are in place for substantive reasons. If my client is caught with drugs and a firearm, and he has a history of violent felonies, but the traffic stop that uncovered all of that was unlawful, then he does not deserve a conviction. If we don't stand by that principle, the entire legal system starts to crumble. Then we ask the next important question: do the facts actually match the charges? Sometimes a punch is just a misdemeanor. Sometimes it's attempted murder. Stealing a phone might be classified as robbery, or it might just be interfering with a 911 call. It's not my job to prove anything. In a criminal trial, I have zero burden of proof. One of my favorite judges always reminds jurors during jury selection. The defense doesn't have to say a single word. They can sit there and silence the entire trial. If the prosecution cannot prove every element of the crime beyond a reasonable doubt, you must find the defendant not guilty. Whether or not my client has confessed to me doesn't matter at that point. The only thing that matters is what the state can prove, using their evidence. And if they can't? I sleep just fine, even if my client is guilty as hell. Story 6. It's not about proving innocence. It's not my job to prove my client is innocent, it's the state's job to prove he's guilty. Period. Once we're past that, here's the next step. Unless my client is flat out maintaining total innocence, this part is actually less important than you might think in case prep. What I focus on instead is this: what can I use to poke holes in the prosecution's case? That doesn't mean proving my client didn't do it. It means undermining the state's version of events. That might mean discrediting their witnesses. It might be my client's own testimony. Maybe my investigator found hard evidence that points to actual innocence. Whatever I've got, my job is to figure out how to get it into the courtroom, legally. And yes, I go out of my way for every single client. Why? Because I like having a bar license, a license I paid dearly for, both in time and money. If I don't run every case through that process, I might as well cut up my license and send it back to the state. Defend is a flexible word. Like I've said before, technical legal rules exist for real, substantial reasons. If there's a legal flaw in how the evidence was collected, I go after it. If the state's case isn't solid enough to hold up in court, I push on that weakness, not because it's some loophole, but because it's the foundation of our legal system. Let's say the cops find evidence of multiple murders in your home, but they only find it through a blatantly illegal search. What do you do then? You've got two conflicting moral priorities: protect the rule of law, or lock up a murderer. You can't pick both in the same case. You've got to choose. And I fall on the side of preserving legal integrity, even if it means a guilty person goes free. As a side note, I've worked with plenty of good cops, and I've never met a competent one who would let a case fall apart that badly. That kind of screw-up is rare. Winning a case doesn't always mean proving innocence. It means getting the best possible outcome based on what my client and I decide is worth aiming for. Sure, sometimes that means getting a not guilty verdict for someone society finds revolting. But more often, it's about damage control, getting the least awful result in a bad situation. Now, does it bother me to defend people like that? Sometimes, honestly, yes. But maybe not in the way you'd expect. Some of the non-violent offenders actually frustrate me more than the violent ones. DUIs really piss me off. I'm not against drinking. But if you're drunk and you get behind the wheel, you're basically driving a 2-ton missile, and you've lost the ability to steer it safely. That's not just selfish, it's dangerous. It's reckless. Same with petty theft. If someone's stealing because they're desperate or sick or struggling, I can understand that. But people who steal just because they want something they can't afford, who act like victims when they're caught, that grates on me. You don't get to take what isn't yours and then cry foul when the consequences show up. Fraud cases can be just as irritating, particularly when the scam is clever and heartless. And don't get me started on drug dealers pushing product laced with fentanyl. You're destroying people for profit, and you know it. What's been interesting about reading through this thread is how you can tell when a lawyer's speaking. It's not just the vocabulary, though some of these posts definitely sent me to Google. It's the attitude, the calm, clinical clarity about right and wrong in a courtroom. And weirdly enough, I agree with a lot of what they're saying, especially when it comes to the crimes that are often brushed off as less serious. Sometimes those are the ones that hit the hardest. Story 7. The system demands it. Sometimes, the non-violent crimes cut deeper than the violent ones. DUIs especially. I'm right there with the original poster. Those can feel more senseless and preventable than some of the worst assaults. But here's the thing, every person, no matter the charge, deserves constitutional protections. That's not negotiable. The Constitution doesn't come with asterisks or opt-out boxes. Defense attorneys, especially public defenders, know this better than anyone. It's not about excusing what someone did. It's about making sure the system doesn't crush them without due process. Even the hardest cases, child assault, for example, have to be approached with a level of detachment. You remind yourself, the Constitution applies to everyone. No matter how much public disgust there is, no matter how guilty someone might seem, you defend the process, not just the person. That's what defense attorneys do. They are the wall standing between the overwhelming power of the state and the individual. If they're doing their job right, they're making sure that wall holds firm. And let's not forget, violent is a legal term, and it can mean wildly different things. The Supreme Court even ruled pickpocketing can count as violent, which, legally, makes sense in certain sentencing contexts, but clearly shows how elastic that word is. Many people accused of violent crimes have deeply broken lives. I knew someone, schizophrenic, who thought a woman was some kind of divine being stealing from him. In his mind, he was reclaiming what was his. In reality, he held her at gunpoint, he just didn't see it that way. His mind was fractured, and no one had intervened before it spiraled. Public defenders often focus on connecting clients to services they didn't even know existed: mental health care, addiction treatment, trauma support. A huge number of women locked up for violent crimes were acting in self-defense, often after years of abuse. I personally know a woman who's been in for 2 decades because she stopped her abuser the night he came after her child. Cyntoia Brown is another name you may know, and she's not an outlier. People who commit violent crimes are still people. Most are not monsters. Most are not Ted Bundy. And even in those rare, horrific cases, the defense still isn't about setting someone free just because. It's about making the state do its job right. I can't stand that cliché from crime shows. He got off on a technicality. Really? You mean the Fourth Amendment? That's not a loophole, that's a cornerstone of your rights. And if we start treating it like a glitch in the system, we've already lost. Story 8, you have to. That's the nature of our adversarial system, and you have to play your part in it. When someone's charged with a felony, it kicks off a long and often brutal process. Sure, it can end quickly with a plea bargain. But it can just as easily drag on for years, crawling toward trial. As a defense lawyer, your job is to lay everything out for your client, the good, the bad, the devastating. If the evidence is ugly, you tell them. You explain what it means, what the likely outcome is. Some clients listen. Some don't. And if they want a trial? Then you're going to trial. At that point, whatever they confess to you, whatever truth they shared behind closed doors, it doesn't matter. You push it to the back of your mind. You lock it away. Because you have one job: convince 12 people that your client is innocent. Even in the most overwhelming cases, you fight to reduce the worst charges, maybe from murder down to negligent homicide or manslaughter. You challenge every part of the prosecution's case. You make the police earn their credibility. If they fumbled the investigation, you shine a light on every mistake. You don't let the state coast. You line up every witness who could possibly help. You work every angle. And when it's time, you put your hand on your client's shoulder and say, "Ladies and gentlemen of the jury, my client sits before you an innocent man." And then you deliver a damn good closing argument. Because that's your role. That's the system. And no matter what the world thinks, that's how justice is supposed to work. Story 8. The system can't afford to fail, not even once. You can't just fight for the innocent. You have to fight for everyone, even the ones you know are guilty, or the whole system collapses. If you only show up for the innocent, you won't know they're innocent until it's too late. That's how people get crushed. That's how justice becomes performative. Take New Orleans, for example, where I work. For decades, defense attorneys didn't fight for their clients. They worked for the judges, not the people they were supposed to protect. No one pushed back. No one held the police to account. And the courthouse became a machine, churning out convictions regardless of guilt. The goal wasn't justice, it was punishment. And unsurprisingly, Black Americans bore the brunt of it. The system was never neutral. It evolved from convict leasing, a post-Civil War way to repackage slavery in legal terms. And those roots? They still show. Now, it's incredibly hard to pull innocent people out of the system once it swallows them. You can't even get a prosecutor to look at exonerating evidence unless you force it into trial, a process that can drag on for 2 years or more. When you finally get there, you often face a judge who seems like an extra prosecutor. And felonies? They carry terrifying sentences. So even innocent people will sometimes take a deal. Why? Because it's safer to plead to something you didn't do than risk 30 years or life if you lose. I've been doing this for 5 years, and I don't believe the adversarial system is the best possible one. There are other models that might serve both victims and defendants better, guilty and innocent alike. But inside the system we have, you don't get to weigh how guilty someone is. You don't get to pick and choose. You fight for your client's innocence. You uphold the law, not your feelings about it. Story 9. Zealously, without judgment. I get this question all the time. People ask, how can you defend someone you know is guilty? And the answer is simple. My job is different than that of a judge or jury. I'm not here to assess guilt. That's not what defense attorneys are for. Now, that doesn't mean I work like a robot. It doesn't mean I have no conscience. But functionally, a lawyer's role is to ensure due process, not deliver judgment. And a courtroom isn't the place for public opinion or revenge. It's a place where our society has decided the boundaries of justice are drawn, boundaries rooted in law, not emotion. That's why all people are entitled to the same treatment under the law. Not because they're all innocent, but because the law can't be trusted to apply itself fairly unless it applies itself to everyone. Also worth noting, attorneys are regulated by state licensing boards. In nearly every state, we have a duty to zealously advocate for our clients. That's not a guideline, it's a rule. And if you can't do that? If you and your client have such a fundamental disagreement that you can't fight for them wholeheartedly? Then you're supposed to step aside. So yes, our legal system is meant to be impartial. And it's designed to protect everyone, not just the people society finds sympathetic. That's why criminal defense is a duty of principle. It's not about ego. It's about believing in the structure of justice itself. And here's something else. A lot of people who've done horrible things truly believe they are monsters. Many of them were victims long before they were offenders. The cycle doesn't excuse their actions, but it gives context. It explains how broken systems create broken people. And if you're familiar with the original position concept from ethics, ask yourself, would anyone ever choose to be born into a life that leads to being hated, locked up, and broken? If not, then maybe mercy matters more than we think. Justice doesn't mean throwing people away. It means honoring the law, even when it's hard. Even when you don't want to. Mercy is meaningful. And equal treatment recognizes that truth is often shaped by the context of our lives. That last line sounded like something Baymax would say. I hope you found this helpful to your understanding. Robotish, sure. But it drives the point home. Because at the end of the day, if your defense doesn't fight for you, really fight, the whole thing collapses. Maybe it's already cracked. Maybe it's never been fully whole. But the answer isn't to fight less. It's to fight harder.